Good afternoon and welcome back to the law offices of Mark Martinez. I'm Mark Martinez coming live from Orange County. And today we're going to talk about the overview of civil litigation. And just a caveat, this area of law that I'm talking about is for small business owners, individuals that haven't gone through the civil litigation process, that are primarily outside of the personal injury realm. And the personal injury realm is a little bit different because most of the time you're not footing the bill. In regular civil litigation, usually you're paying money up front, so it's a little bit more, you have a little bit more of an emotional investment in the case, let's say. So I'm just going to go over an overview and some of the common questions that I receive from my clients. We do real estate litigation, we do some contract disputes, civil litigation, things like that. So these are situations that some of our clients ask questions on. The first one is, in the unlimited civil litigation process, I'm being sued or I want to sue somebody, do I need an attorney? And my first recommendation is most likely. And I say most likely because civil litigation is a high-stakes game. And typically what I mean by that is the amount of time, energy, and money that the parties have to invest is so great that if the damage or the value of the case is minimal, it probably doesn't make sense to initiate a lawsuit. And typically, when I look at a case, if the damages to either side is less than $50,000, a lot of times it's something that is not very interesting to my office. And the reason for that is because you're going to be spending a lot of money on your attorney and on their office in battling this case, whether to recover damages or to prevent damages from being recovered from you. So in either way, there's going to be a lot of money changing hands. So you want to make sure that there's value to the case. The other thing is, I do have another video that talks about why you should have an attorney. And I will just say briefly here that you should definitely have an attorney, even if you are an intelligent individual that believes they know the law. Practicing law is not only the book knowledge, but also the experience gained by going to court over and over. And also, as an attorney, you're not emotionally invested in the case, so you're able to distance yourself a little bit and make, I believe, a little bit better decisions at times. So that would be the first thing as far as whether or not you need an attorney. And the final answer there is most likely you're going to need an attorney. The second question that I get a lot from clients is, well, how long is the civil process? How long is this going to take? And the quick answer is it's going to take a long time. Civil litigation from the beginning to up to trial is about a year's time. But if a lawsuit is filed, the first court hearing a lot of times is not for a good 3 months. And that's where a case management conference is held, where the parties just check in, see what the case is about. And then from there, they may or may not set a trial depending on what the course of action is being taken in the case. Typically, in my office, during regular times, cases, I quote anywhere from 12 to 18 to 24 months, depending on how many continuances are being granted, what the parties want to do with the case, if they want to get it done quick or fast, or if one of the parties wants to drag it out. So it could take up to a number of years, so just keep that part in mind. Now that there's COVID, everything is delayed. And so everything is going to take a long time in my professional and personal opinion, for a number of years due to the backlog for COVID in Southern California. So be ready for the long haul. The third question that I get is, what are my chances of success? Mr. Martinez, can you give me a percentage? What is the percentage of us winning this? And I typically, I'm not totally against giving a percentage, but usually I speak in terms of whether the case is a strong case or a weak case. And the reason why I don't speak in terms of a percentage is because I'm not the decider of the case. There's cases I believe I've worked very well, and the judge or the jury at the very end just didn't see the case the way that I believe that I presented it. And so there's a lot of things that are outside of my control. There's other cases where at certain times we've, gone up against a weaker law firm, and we've been able to turn what appeared to be a weak case into a winning case. There's a number of times where I assessed a case and had X amount of damages and recovered over and above the damage amount that I quoted the client, much to their excitement. And, so there's definitely a lot of factors to take in. And so usually what I like to speak in terms to the client is vague terms, and but at the same time give them some type of estimate. And so usually I just project it as being a strong case or a weaker case. And that also sets the tone. It sets the tone for how to dispose of the case, trying to put a value on the case and how hard you're going to fight, or what a realistic resolution of the case may be before trial. The other part of that is, the other question is, do I have a winning case? The other question I'll ask my clients is, well, what are your goals? What are you trying to accomplish? And so each thing is specific. There's, that phrase winning is a very vague phrase when it comes to cases. Let's define what that means. Let's see what your actual goals are. So if you call into my office, that's one of the first questions that any staff member here will ask you if you're not a client. Well, what are your goals in having us represent you in this case? And that's what we're really trying to do. We run a client-centered law firm here where we're trying to look and see if our client, one, has realistic goals. Two, even if their goals are unrealistic, do they know that they're unrealistic or they have a lesser chance? And three, what are they willing to do to achieve and accomplish those goals? And if we can get those all aligned and we can all get on the same page, then we're going to want you as one of our clients, and we're going to want to fight as hard as we can for you. As required by the California Bar, we have to zealously represent our clients. Number 4, another common question that I get is, how much is this going to cost? And the best answer I can give you is a lot. And I say a lot because civil litigation is, in certain ways, it's a wealthy man's game. My billing per hour is $350 right now, and I don't bill for every second that I'm, thinking or working on a case or double bill clients, but I definitely bill for the time that I'm working on a case, and naturally it adds up. And naturally it adds up because there's so much work that needs to be done over time. So I don't ever have to look for work to do on a case. The work is going to be there, and there's going to be a lot of work. You can expect to, prior to trial, in let's just say a year's time, depending on what kind of firm you're working with, you can expect to go through, on the low side, I would say probably $15,000 in a year. On the high side, probably 50 to, if it's a business litigation, probably even higher, maybe 70,000 before trial. something along those lines. So there is a little bit of a spectrum, and it's still hard to estimate how much it's going to cost before trial. And the first thing I would say about the cost is it depends on what you are willing, you and your law firm, you and your attorney are willing to do to build a winning case. And what I mean by that is a lot of attorneys in civil litigation charge hourly. And what that does is there's certain phases of a case. So the first thing to do is the pleading, where you get out a complaint, and that's going to take a number of hours. And then you go into discovery. And discovery is where you present all your evidence and you ask for evidence on the other side. And here is where it could get rather costly because it's very time consuming. Discovery is the process of asking 1,000 questions to the other side, and the other side asking you 1,000 questions in written form. And so you can object to these questions. You can, do a little bit of lawyering. You can subpoena records. You can have depositions taken. All of these things add up within a 6-month, but it's not very quickly. It does take a little bit of time. This is about a 6 to a year process in going through discovery. It's just complete and always ongoing, where you're just really getting to all the evidence. What paperwork do you want to see, Mr. Martinez? All of it. We want to see all of it. The best, the competent attorneys out there, I can't even say the best, the competent attorneys out there, they want to see everything. They want all the evidence and all the subpoenas, all the witnesses, everything. And here's where, in certain situations, I have clients that they just simply can't afford going all in on these cases. And so the budget is something that we have to think about. We have to strategize based on the budget. I can't treat every client like a corporate client where they just have a blank check and I just start working on their case. Sometimes we have to strategize and we have to do less discovery. Maybe we don't do depositions of everybody involved. Maybe we do 1 or 2 depositions, or maybe we don't do any depositions. Most of the time, that's lessening the strength of your case, but at the same time, life isn't perfect, and sometimes it's necessary. I will say this. I will say that in civil litigation, there's momentum and there's leverage. And so you don't want to just go out there and, just blindly hand over money to your attorney. You want to understand what they're going to do for you. And what I can say is, at our firm, if you're paying us more of the hourly, you're going to see some of the evidence gathering and building the case early on. And we encourage to do that because that's going to give us more leverage to negotiate. We're going to come from a point of strength rather than a point of weakness. And what I mean by that is, once a case starts, the defendant, well, they always want to settle. And the plaintiff, once a case starts, well, they always want to settle too. But the problem is, the plaintiff wants to settle on this side, and the defendant is hoping to settle over here. And as you can see, my hands aren't even in the picture. So the process of discovery, a lot of times will bring these two sides a little bit closer as far as settlement before trial. And so that's a part where, as you're building your case, as you're going through the evidence, that's why competent attorneys want all the evidence, so they can look and see how strong a case is going to be or how weak a case is going to be, and hone in on settlements and things like that. Which brings us to our next portion of civil litigation, the overview process, and that's settlement. And settlement is always valuable. The way that we work is we're always trying to settle cases. We're always trying to settle cases because it's valuable to the client. Why not try to settle a case? You're paying us by the hour. Why don't we just pick up the phone and see if we can settle this thing right away? And what I say by that is, I'm not trying to devalue or take money out of my client's pocket, but once again, we go to the goals. What are the goals here? What do you want out of this case? And so we try to look and see if we can get the number or get the value that we're looking for early on before our client goes down a dark hole with us. And that can be done in a number of ways. There can be formal offers sent to the other side. There can be 998 offers, what's called mediation. There can be formal mediation. There can be mandatory settlement conferences with the court where there's neutral mediators involved. There's a number of different ways that a case can settle. And the closer you are in the amount, it usually appears that's those are the cases that are more likely than not that are going to be settled. If one side wants 100,000 and the other one is 0, maybe mediation is not the right way to go, because it's going to be very difficult for a mediator to bring you guys together. If one side wants 50,000, the other wants 60, and there's a $10,000 gap, well, that case is going to settle. It just makes sense, and the attorneys, if you have competent attorneys involved, they're going to encourage their clients to look for that compromise. So always keep in mind that settlement is part of the process. It's an ongoing process. It just doesn't happen overnight or on a specific day. It should be happening throughout a case. And then the other thing that I would mention as far as settlement is concerned is what a response looks like. And a lot of times my clients will be on the low end starting in a case, and there's a lot of emotions involved, and they throw out an offer to the other side. And as their attorney, I don't mind communicating it to the other side and trying to convince the other side. But sometimes some of those offers don't even get responded to. And I think that's important as well, because my philosophy is when you present an offer to the other side and it's not responded to, usually that speaks louder than anything else they can do, which means they're not interested, and you're so far apart from what they want that it's just not worth even negotiating. That's what I've found out a lot of the times. Of course, you're following up, you're making sure that they got the offer, that they're looking at it, things like that. But if they're not going to respond with a counteroffer, they just don't think it's worth their time to start the negotiation process at that time. And usually it's because you're just too far apart in the numbers. Finally, the sixth overview is my personal philosophy, our office's philosophy on why to go to trial. And our philosophy on why to go to trial is primarily for one reason. And this is about civil litigation. And so if we're representing plaintiffs, the only reason why we want to go to trial is because we believe we can get more money if we go to trial. As defendants, if we're representing you as a defendant, the only reason why we want to go to trial is because we believe that you can pay less if we go to trial than any of the offers we've received in settlement. And so there is a risk in that, but at the same time, it's a calculated risk. And trial is would be for another video. And there's a lot of preparation, and there's not going to be, the control is now out of your hands. So there can be, the consequences and the risks increase. High risk, high reward, high risk, perhaps a high judgment against you. So it's just, the preference that an individual has. And then also coupled with trial is the most expensive part of the civil litigation portion, aside from preparation of trial, the 60 days before. So thank you. That's the overview of the civil litigation process. If you've been sued and, this is, you're not a regular individual that is familiar with the lawsuits, this is a helpful video to kind of get you familiar with how the process works, some of the things to expect over the time of the lawsuit. And I wish you the best of luck.